Good evening, everyone. As president of the European Law Institute, it is my privilege and pleasure to welcome you all to this webinar on the protection of adults in international situations. The European Law Institute just turned 10 and celebrated its decennial on 1st June 2021 during a one-day event. So we might not qualify as adults. We wanted, however, to feature in particular manner ELI projects that have been recently completed through a series of webinars. This is very important to me, given the aim of the European Law Institute, which aims at improving the quality of European law, especially by making recommendations, providing practical guidance, and stimulating European legal developments in a global context. It is indeed not sufficient to complete those projects, but really to present their ideas to the community, to welcome external views on them, and engage in debates and discussions that truly create a European community of lawyers and understanding. The project on protection of adults in international situations was completed in 2020 during the core of the COVID-19 pandemic and was published. It is therefore one of the first dissemination events of this very project, given that all other attempts had to be postponed because of the pandemic. I'm therefore very proud and honored to be able to welcome you all tonight for this webinar. Indeed, we would have loved to have you all in person, but this is realistically just not possible. And who knows for how long? Nevertheless, those remote meetings and discussions are an essential tool to keep us exchanging ideas, to foster the community of lawyers in its diversity, of course, but also in its capacity to speak as lawyers for improving difficult situations. That should not just be left to politicians. I want tonight to take the opportunity to thank very warmly the reporters of this project, Protection of Adults in International Situations, Professor Pietro Fanzina from the Catholic University of the Sacred Heart in Milano, and Mr. Richard Shrimston, a consultant at Russell Cook, for their incredible work. They were supported by a number of colleagues throughout Europe in a team that worked well and efficiently to produce this report and a checklist intended for practitioners to encourage the development of private mandates within the ambit of substantive laws of the member states. Thank you very much, Pietro and Richard, for all your work. Tonight, we have the pleasure and the honor to have a panel of very distinguished speakers who will no doubt pick up some of the challenging ideas developed by the reporters of this project. So let us not wait before listening to all these wonderful panelists. I therefore give the floor to Aneta Wiewiórowska, who will chair today's webinar. She's a member of the Executive Committee of the European Law Institute and a senior research fellow at the University of Osnabrück in Germany, while also being very active in Poland on several levels. Thank you very much, Aneta, for chairing today's webinar. And I wish you all and wish we all a wonderful evening. Thank you. The floor is yours.
Thank you very much, Pascal. It is indeed my pleasure to host the seminar today. And I will not really hide that this subject is somehow outside of my area of expertise. So I'm here on the teaching curve, so to say. So I will not be doing any kind of substantial introduction, but I would like to just give you some household rules. So we are going to have 6 presentations, which will be followed by a question and answer session that I will coordinate. I would like to appeal to the speakers to stick to the time schedule because we are rather short on time. And this is the end of my introduction. And I would like to ask to take the floor Professor Pietro Fanzina, who, as Pascal already said, was one of the co-reporters for this project. He is a professor from at the Catholic University of the Sacred Heart in Milano. He joined this university in 2020 as a full professor of international law. This year, 2021, he was appointed as a director of the Institute of International Studies. He teaches private international law and transnational law. His main scientific interests are in the area of private international law, and he's among the founding members of the European Associations of Private International Law and serves as a Deputy Secretary General to this association. Professor Francina, the floor is yours for exactly 7 minutes.
Thank you very much. So I've been asked to provide an overview of the ELI project on the protection of adults in international situations. Of course, the time is very limited, so I will try to concentrate on very few points. I have picked 5 points which I consider to be important and still important almost 2 years after the project itself was completed. The first point has to do with the fact that this project of the European Law Institute represented the first Europe-wide opportunity of discussion of this topic. Back in 2017, when the project was launched, this topic of the international protection of adults was a relatively neglected topic, with some specialists, Richard Frimston among others, of course, but very few, and not so much of a community of legal practitioners committed to exploring the issues surrounding this field. I can say that today I witness a significantly increased interest in this topic on the part of academics, legal practitioners, stakeholders in general, the CNUE, for example, so the Notaries of Europe, just to mention one, and many others. I think that this is due to the commitment and involvement of several actors, the Permanent Bureau of the Hague Conference on Private International Law, of course, but I also think that the ELI project played an important role in increasing the awareness on this problem and fostering the debate. Second point I would like to mention, the experts involved in the project were all in agreement on the fact that the Hague Convention of 13 January 2000 on the international protection of adults provides balanced, finely crafted solutions and works generally well in practice. So what was interesting in noting right at the beginning of the project that there was a very broad consensus on the advantages of having the Hague Convention as the key, the framework, the legal framework of this area of law, the key instrument to deal with these problems. This is interesting to note because at that time in particular, I don't think this is any longer the case, some not the members of the project team of the European Law Institute, but some others were of the opinion that the Hague Convention could serve as a model and probably not more than that. Whereas the project provided an opportunity to come to the conclusion that the Hague Convention should not just be a model, should be the basis of a well-balanced and workable solution of the problems raised in this area. Third point, the project stressed that the EU as such should do something in the field of the protection of adults in international situations. We agreed that there are very strong reasons why the European institutions should take action in this field, both for the purposes of ensuring the effective protection of the fundamental rights of those involved, and for the purposes of ensuring mobility of persons and assets for the good of the internal market and the area of freedom, security, and justice. Fourth point, The EU, that's the opinion suggested in the conclusions of the project, should take steps to ensure that all member states ratify the Hague Adults Convention. The European Union institutions have been active in monitoring ratifications and accessions throughout these years, and recommendations have been issued in this respect. The opinion of the draft of the report, of the project is that the European Union can and should do more than monitoring, and should in fact, and has the power, the external power. This is a very controversial issue and which I'm not discussing here, but that's the opinion that came out from the project. The European Union has the power and should use this power to ensure that in fact, all member states that have not yet done so ratify the convention or accede to it. Fifth and final point, the EU should do more than that, more than just exercising its external power in this respect. It should also take internal measure aimed at improving the operation of the convention in the relations between member states. Let me stress this. This EU legislation and more generally measures that the report believes necessary or desirable are measures that would complement the convention without creating an interference with the convention. To some extent, these measures would derogate from the convention, which is something that the convention itself does not exclude. A provision within the convention allows for this kind of derogations from the convention by contracting states. But still, the idea of the project members is that the EU should do something internally at an EU level, through legislation in particular, with a view to complement and make the convention and make it stronger in the relationships between member states of the European Union. I will keep to this, which are very basic information, but I'm very happy that Richard Frimston is here to provide more details on the kind of measures that have been proposed in the report. Thank you.
Thank
you very much, Pietro. And it's great to see so many people here. Sorry, Agneta, did you?
No, please go ahead. I just wanted to give a few words about you. And actually, I wanted to honestly praise Pietro for giving extra 30 seconds to every speaker that follows him. That doesn't happen too often, but please go ahead.
Thank you very much. Well, we'll all do our best. And it's great to see so many friends and colleagues and people who worked on this report attending this webinar. Really, I think what I wanted to do was concentrate as a practitioner on what individual citizens and clients want. And I would stress that I think Pietro is quite right in saying that everybody involved in this field is very enthusiastic about the 2000 Convention. It does a really good job in relation to the applicable law, recognition and enforcement and jurisdiction for measures of protection. But for clients, they want to avoid going to court where they can. And that's where powers of representation are so important. Equally, we had the UN Convention on the Rights of Persons with Disability, which was finalized after the convention. And the recent joint statement of the 8th of July 2021 makes it clear that the Hague 2000 Convention is not in contravention of the UN Convention, but complements it, and that the Hague Convention should be interpreted in the light of the UN Convention. But the UN Convention very much stressed the autonomy for individuals and the rights of individuals for autonomy. And the basic problem in the field of vulnerable adults is always somebody with full autonomy has no protection, somebody with full protection has no autonomy. And it's powers of representation that solve that conundrum, because it enables people, whilst they have full autonomy, to say who they want to deal with their affairs in order to protect them when they can no longer exercise that full autonomy. And therefore it is the powers of representation that are vital for citizens throughout the world. And the Hague Convention, whilst it's great on measures of protection, really, having been based on the on Hague 34 for the protection of children, that powers of representation were somewhat of an afterthought, or added into the Hague 35 in a way which is perhaps not ideal. And there's numbers of areas in relation to powers of representation where there are some weaknesses. So the Article 38 certificate in the Hague Convention, whilst admirable in principle, can only apply if a power of representation has been confirmed, and many powers are not confirmed. Similarly, in practice, whilst the law applicable to a power of representation will be clearly defined, the actual law that is used in relation to the manner of exercise will be the law of the state in which the power is exercised. And that's where, in practice, there are so many problems, because the boundaries between the existence of a power and its extent and the manner in which that power is exercised is very grey and quite difficult. So certainly from our work on the report, we did come to the conclusion that a power of representation really is vital for individual citizens. And we did think that, having looked at the succession regulation in particular, that the EU has been very good at thinking about how to improve the circulation of documents and how to make them more effective in the European Union. I'm sad that I'm now a national of a state which is no longer a member state. I'm sad that England and Wales has not yet ratified the convention, but I'm hopeful that it will do so next summer. Clearly, within the UK, Scotland has ratified the convention and uses it fully. But certainly some of the other areas in relation to powers of representation we've covered in the report, but I think the main issue that we would stress is that the idea of a European Union certificate of a power of representation would mean that a power was fully usable and much more able to be used by citizens, whereas at the moment, although the Hague Convention is a great convention in relation to measures of protection, individual citizens find that in practice, they need to have a separate power of representation in relation to each state where they have assets. And that's not a sensible way for the world to run. So I think that probably concludes what I would want to say, but to stress that from a practitioner's point of view and from citizens' point of view, it is powers of representation that are the most important. They want to avoid going to court, and anything that can be done within the European Union to improve the free circulation and acceptance of powers of representation would be a great step forward. Thank you very much.
Thank you very much for this quite practical view on how the protection measures should work. And our next speaker, and of course for keeping the timetable, our next speaker today is Adrian Vasquez Lazara, member of the European Parliament from Spain, who is a member of the Renew Europe Parliamentary Group. He is chairing the Legal Affairs Committee, and he's a substitute member of the Agricultural and Rural Development Committee he was heavily involved in creating Renew Europe before becoming member of the parliament. And apart from that, he has a very, very solid academic background with Master's International Relations from the University of Warwick and a degree in International Studies from the University of Lindenwood. Mr. Vasquez Lazara is going to present the European Parliament's work on the protection of adults in international situations, as culminated in the 2017.
Thank you very much, Aneta, for the kind introduction. And also I want to thank you, President Professor Pichonats of the European Law Institute for inviting me to speak in such an important topic. I will start a little bit by replying to one of the previous speakers, to Professor Francina, that he gave a really good overview on the situation. But also, I want to, of course, somehow defend everything that has been done in the European institutions. The problem is that basically we are not followed by many member states. That's the main issue that we have to confront. I have to recall that in the European Parliament, in general, in particular in the Legal Affairs Committee, the committee that I chair, we have shown a long-standing commitment with the improvement and consolidation of the cooperation tools and mechanisms to better protect this group of European citizens. In this regard, I would like to draw the attention to that legislative initiative that you have already mentioned, that was drafted and approved already in 2017. I was already in the House, in the Parliament. I was not a member, but I was already working in many legislative files like this one. And basically that resolution, what it was doing was applauding the member states that had ratified the Hague Convention on the Protection of Adults of 2000. But since then, the convention, as we all know, has only entered into force in 10 countries, which 9 of those are member states of the European Union. Therefore, that means that the remaining member states are not applying today the main international cooperation tool that we have to protect vulnerable adults, which is just as worrying as the absence of almost any non-European Union country in the list of the states where the convention has actually entered into force. So what we want to do, of course, is one of the main goals, as it has been said before me, is to promote the ratification of this convention, but not only within the European Union borders, but also beyond those European borders. To do so, I believe that beyond what other big countries or big states have, the strongest weapons that the European Union has to do this is soft power, and basically the international treaties. There is no secret for everyone that the trade policy and the power of our internal market is probably the best and more efficient vehicle to export European priorities and values, to actually standardize our values in the form of legislation, not only within the Union, but also beyond it. Therefore, a holistic approach on the protection of vulnerable adults should include this perspective and make the ratification of the Hague Convention one of the requirements to meet in order to reach certain trade deals with the Union for third countries. And that doing things like that, not only in this particular topic, but also in others, it will be a great boost to actually make other countries to ratify the convention. I want to go back to the Parliament's 2017 resolution, which is important to recall that the text went far beyond the commitment to the Hague Convention. And I want to defend or to actually highlight the three main principles that the Parliament and the Committee always defends on this topic. The first one is that the European Union shall take action in order to ensure the rights of vulnerable adults to move freely and to reside in the member states of their choice, as well as to have adequate protection for the property if such property is located in more than one member state. To this end, we must establish uniform provisions concerning the jurisdiction, applicable law, and the recognition and enforcement of protection measures for adults and for their property. Second, we need to ensure an improved communication and cooperation mechanism between the authorities of different states, like the previous speaker said, involved in the protection of vulnerable adults. And third, when it comes to third non-EU countries, the EU must keep reaching multilateral agreements in the area of civil justice cooperation, as they are key to increase trust between the national judiciaries and provide legal certainty to citizens. The experience has shown that the Hague Convention is not enough to reduce legal and emotional costs for vulnerable adults when facing issues, for instance, in cross-border situations. Thus, we should promote those legislative measures aimed to improving the operation of the Hague Convention in the relation between member states, consistent with the objectives of itself and its governing principles. Besides those three main points, that is basically what the 2017 resolution defended, I would also like to touch upon the promotion of a justice system that is better suited, better prepared to deal with cases involving vulnerable adults. In this regard, I would like to recall something which is quite important, and it's the last multi-annual financial framework that established within the framework of the Justice Program for 2021-2027 a special reference to the provision of funds for training courses for judges, lawyers, and prosecutors about the challenges and obstacles experienced by people who often face discrimination or are in a vulnerable situation. And this is paramount. It's the first thing that something like this is included in such multi-annual framework. So that is why the support should be given in particular to activities which facilitate effective and equal access to justice for persons who often face discrimination or are in vulnerable situations. Also, we believe that the program from the European Parliament, the program should also contribute to improve access to justice by promoting and supporting the rights of victims of crime, as well as the procedural rights of suspects and accused persons in criminal proceedings. On the whole, I like to say that the European Parliament, Legal Affairs Committee, and well, myself, we are really involved and really pushing to stand ready to try to continue contributing on the EU's policy in the protection on vulnerable adults, and of course on putting pressure on the member states that have not yet ratified the convention to do so the sooner as possible. Thank you very much.
Thank you very much for presenting the views of the Parliament. And now we are going to proceed with the views from the Commission. They are going to be presented by Sala Sastamoinen, who is Director for Civil and Commercial Justice in the European Commission, the Directorate General for Justice and Consumers. She leads the development and consolidation of European area of justice, in particular for civil procedural law, private international law, contract law, company law, and corporate governance. For 2 years, she worked acting as Director General for DG Justice and Consumers in 2020-2021. Earlier, she has been Director for Equality in DG Justice and Consumers and had several headed unit functions. I cannot see whether we have her. Yes, please take the floor.
Thank you very much, Chair. And good evening to all the participants, and good evening to all the panelists. So it's a pleasure to spend this evening with you. I would like to thank ELI both for the invitation and both for having been active on the issue of the vulnerable adults. It is the Commission has worked also on this subject quite a long time, but it is quite correct that now the issue has activated. I will start with some of the general remarks from our policy perspective in this one. First, reminding that we have also in this Commission the issue of the demography in the very important place. In the last 50 years, life expectancy has increased by some 10 years. So this makes aging one of the most, let's say, crucial phenomena in the EU in the coming decades. Already today, the protection of vulnerable adults constitutes quite a significant proportion of the work of national courts. So there are cases, we are studying in the matter. Our example is, for example, from the year 2017, when almost 700,000 protection measures were adopted in a group of 7 member states. We were then that way in that moment consulting. So also very relevant from that perspective. And then the free movement within the EU, both within EU and also the migratory flows bring the situation where we have more people living in another member states, in the states different that they were born or where they used to work. And that brings more situations also where the protecting the rights of the vulnerable elderly and the persons with disabilities has become also a political priority. So what we have done, so we have indeed worked. It's nothing new as such. Naturally, the Hague already, the convention is from year 2000. If I look in the Union under the French presidency, 2008, all member states concluded already that it was their interest to ratify this Hague Convention. 10 years, so let's say since the Commission has also been promoting the adhesion to the Convention. Some milestones, for example, 2018, so we had just in 2017 resolution of the Parliament. We organized a big conference on the cross-border protection of vulnerable adults, together indeed with the Hague Secretariat. But despite of all these efforts, there are only 10 member states that are party to the convention today. So this is not, we have not been so successful in our efforts as we were thinking or wanting, let's say so. Let me say some words why we have been pushing for it. I mean, some concrete examples why there are still then concerns for the vulnerable Europeans. If we take an example, for example, in one member state, a person is suffering dementia with a legal representative and has a house on accounts in other member states. So to help this person, the vulnerable persons, the legal representative must go through many hoops. They starting from getting a proof that they are in fact the legal representative, even if it has been already then recognized in their home member state. The more complicated the person's assets are, the more complicated and expensive is managing these assets when you do that across the borders. A measure of the protection is one thing that is automatically recognized by the 2000 Adults Convention, if the both member states are there. But as they not are, as they are, or not all are, so 17 not yet ratified, the vulnerable adults in any cross-border civil case, there are currently several problems and concerns. So we do not have these EU-wide rules to determine which court would have the jurisdiction. We are missing the EU rules on which legal protection rule would apply, as well as we are missing the recognition and enforcement rules on the decision of the court. So in this situation, we are indeed very happy that the discussion and the interest has activated. It has activated both from the perspective of the academic life, but also in political life. And the EU and the Commission has now included in this this year's adopted work program. It mentions that we are working for the EU level rules on the vulnerable adults. I'll come back then to the timing and the process. But it is then EU level rules. So what we are talking on the possibility of having the EU regulation. So one thing is to have the 2000 Convention of the Hague applicable all member states. And then another thing is that we could go in somewhat further in certain aspects for the vulnerable adults and their relatives in the EU. It is the principle of the mutual trust, mutual recognition on which the European area of justice is built on, and that allows a strong cooperation and the removal of barriers within the EU. We have done this in several areas of the civil justice or cross-border civil justice. In many, let's say in nearly all cross-border civil matters, we are already facilitating citizens' lives, whether it's a succession or the divorce or the parental rights. But there is this gap on the protection of vulnerable adults. So some of the possibilities that we could then bring that further on facilitation of this for the vulnerables within EU. One example, like what we have done in the contractual maintenance or divorce matters, the exequatur could be abolished and the grounds for the non-recognition could be limited. In that way, the circulation of the decisions could be quicker and less expensive, and the legal certainty would be also improved. In many member states, it's possible to arrange in advance the conditions of the protection for the time when a person is not anymore in the position to protect own interests. And that was very well presented already by Rita Frimston before. So we are talking about these private mandates or powers of representation. So this is something indeed that where we could also bring European level powers or certificate. We could also make it possible that the person establishing that kind of the powers or mandate could choose the competent court in advance. So it is this party autonomy that we could increase at the European level. And actually, when we talk about the cross-border aspect, it's about the working with the many languages, and there the use of the multilingual standard forms, as we have done in the various EU instruments, could be also a way forward. So it could be there's EU certificate of representation that we could bring further. And further, we could simplify the cross-border cooperation, the cooperation between the authorities, and that way reduce the administrative burdens for the authorities. And we also, when we talk about then of using the rules of other member states, it's about the access to foreign law. And that is then, for example, through e-justice portal, we could improve that and broaden that specifically to the area also of the protection of vulnerable adults. And my final point is then how we could tackle this area is the further use of digital tools. I mean, we have just now, last week, we proposed a new regulation on digitalization of the cross-border judicial cooperations for the communications between the competent authorities and central authorities. And naturally, that's something that we could then also have in the area of the protection of vulnerable adults. So there are already then, on the basis of all the work that has gone, thank you very much, ELI, thank you also for the Parliament's work, there are already then ideas how to go forward. But we still need to work before we come out with any proposal. So what we need to do, we need to know what is the true extent of the problem. So that means that we have to evaluate the impacts to make sure that any proposal could not or would not impose additional costs or red tape, but it really would simplify the rules. And in order to assess the impacts, we need to study. So what we have done, we have already carried out a legal study where the results are coming now. We are mapping the legislation of the member states and looking at the situation there and how it can be improved. We are also now launching an open public consultation that's called a call for evidence in the coming weeks. So even then before the end of the year. And we are very grateful and if you are participating to that consultation. So this is my message to all the participants. Please follow this. Please give your views the views of your professional networks. It's crucial for us to have these opinions before the initiative. And it's really accessible. We try to make this call for evidence so that it's accessible to everyone, for the citizens, experts, legal practitioners. So anybody could reply in all the naturally available in all EU languages. The studies we have had the legal study. We will still need to complement that with the further impact assessment study on all the policy options and the quantification of them of the problems. And naturally, the consultations are also continuing throughout next year. So this means that this process takes time, so that we are talking about the possible proposal beginning of 2023. So this is where we currently aim at. It would be still in the mandate of this commission and would enable the negotiations in the council and in the parliament, importantly then in this mandate. I'm finishing with referring to this UN Convention on Rights of Persons with Disabilities. It was also mentioned by the previous speakers, very important, because naturally the Commission proposal will be in line with the principles safeguarded with this convention. So this is the important frame for the fundamental rights of vulnerable adults, also taking into account from the point of view of the UN Convention. So with these plans, we are drawing of what all you have already done in those both in ELI, naturally from The Hague, all the political guidance from the Parliament, and we hope to, through this broad consultation, to get it even more focused and improved, to have the policy support for the proposals in the future. So thank you very much for today's discussion. It is very useful for our project.
Thank you very much for this very insightful presentation. And before I give the floor to the next speaker, I would like to appeal to our audience to pose the questions on the chat, so we can gather them before the questions and answer session. And our next speaker is Philippe Lottie, first secretary of the Hague Conference on Private International Law. He's been serving as the first secretary since 2001. And his primary responsibility is the 2000 Protection of Adults, the 2007 Child Support Conventions, as well as the 2007 Protocol on the law applicable to maintenance obligations. He's also has responsibility for the International Hague Network of Judges, including direct judicial communications and the Judges newsletter. He's responsible for the development of information technology tools in support of Hague conventions, such as the iSupport electronic case management and secure communication systems under the 2007 Child Support Convention. The floor is yours.
Thank you very much. It's nice to see so many friends of the Hague Conference on the panel. All of you I know in person, except Adrian. Eventually we'll get to meet each other at some point. Thanks for your support on the E-Codex regulation lately that went through Parliament. That's been very much appreciated. Well, thanks to ELI for organizing this very good panel at a very good moment, and all our very best on your 10th anniversary. This is quite a landmark, and it's good to see that things are moving well at ELI. Well, we've been busy at the Hague Conference at the Permanent Bureau on the 2000 Convention, and as Sarah mentioned, back in 2018 we had a joint conference together, and we took from this joint conference actually a number of conclusions, recommendations from more than 130 participants that were representing, many states around the world, not just in the European Union. One of those conclusions and recommendation was to make a suggestion to our governing body to actually hold a special commission, that is a meeting of states parties and members of the organization, to review the application of this treaty. And we have taken this on board. Our governing body actually, secured this, approved it, and agreed that we have a special commission that would actually be taking place in the third quarter of 2022. On the basis of this decision, we have actually done what we do usually, is we had circulated a questionnaire to our states parties and also members to review the practical operation of the convention and to know whether there were any problems concerning this convention, and also to see from them whether there were extra tools that needed to be developed to actually further the implementation of the convention. So we sent out this questionnaire. It came back. There are no indications of problems with this treaty. It has jurisdiction rules, applicable law rules, recognition and enforcement rules, and cooperation rules, and they are working very well, we're told. And we've assessed this in our recent work. Another wish, actually a wish that the members have actually expressed concerning this convention, is that we develop a tool, a guide for its implementation. And we have taken this on board. The council agreed that we move forward with this, and work has started last April. And by the time I'm actually speaking to you, we have a draft guide. It's now in circulation with a group of practitioners and academics in the area called FLEUR Europe, it's Family Law Europe, and we're to receive comments from them in early January. And by mid-February, the draft guide for implementation will be circulated for comments publicly. Member states, but also NGOs, STEP included, which Richard is a member, the CNU that made reference earlier by Pietro, all of those we're welcoming comments. It's been great work. Gerardo Ribeiro is the chair of that working group. He will speak to the working group. But I must have to say that we have 11 states parties in that working group. It's working extremely well. We've achieved consensus on the guide, and there were no real problems identified. A few questions need to be resolved. We're working on this at the Secretariat. One question is whether advanced directives are part of powers of representation. Our primary conclusion is yes. Gerardo today actually shared with me an article he wrote some 13 years ago to the effect that he's of the view that they are included, but our research in the proceedings are to the effect that they're included. We will also have a document that will deal with the status of ex lege powers in the treaty. They are covered by the treaty, but they don't have a specific provision, but we'll articulate this further into a document that will be distributed to members. So we're working on this. I will leave it here for Gerardo to say a few words on that. Our next step is actually to develop a country profile. That is a tool to access the foreign law in the different states. So it saves the same purpose as the fact sheets that Sara Sassimonian referred to. It's a bit different, but it's directly related to the application of the treaty, and that will make it a lot easier to work, especially in the area of powers of representation that Richard has talked about. There's a lot to be learned, and and it's not just a lawyer's job. What we realize developing the guide is that it's the non-lawyers actually that need to have more information than anybody else. It's the bankers, it's the medical staff, and we have to make their lives as easy as possible, and we have to keep it as simple as possible. So this is where, when we talked about another, norm at the European level, we have to keep in mind that this area is not just for lawyers. There's a lot more, and it is very different than other areas that we work from usually. It's a different category of people, and we have to keep it simple for them. That's very, very important. So this is the work in advance of the Special Commission. This being said, yes, there are only 10 EU states parties to the convention, but I think it's important to just take a step back and to realize what we've been going through during the last 15 years or so. The 2006 Convention on the UN Convention on the Rights of Persons with Disabilities has been mentioned. That is a convention of 2006. It is a revolution in this area. I mean, it's a great revolution, a positive revolution. And a lot of states have been really busy implementing that treaty properly. And this has been their priority. This is what we learned. They want to do the implementation of the 2006 first, and they don't want to do it well before they move to the 2000 convention. And that's the reality. And politically speaking, the UN CRPD touches every citizen in every state. where the 2000 convention will touch upon incapacitated adults that are in a cross-border situation. That is probably less than 2 or 1% of the constituent. So this is where they have, put their priorities. And we have to remember that. We have to be respectful. States are trying to do their best. We have to remember that. The other thing is, well, they all have been struck by economic crisis since 2008. That has changed their legislative agenda. I'm not trying to find excuses for them, but that's the reality out there. Then we've been struck by a pandemic. Out of the joint meeting in 2018, we had actually on our radar screen a number of states working towards ratification. That included Malta. That includes also Ireland. It includes also Sweden. They're all working away, but suddenly, yes, its priorities have shifted. So that's the pandemic. And now it's the economic recovery from the pandemic, which is also a priority. It's also climate change is a priority. It's been all over. So, I mean, they're working hard, and I think they're, trying to do their best. But what we know is this guide to implementation will help a lot of states to move forward. It's a very good guide. And I just want to say a few words in reaction to a few things that Sala Testimonian mentioned. In devising the guide, and Pietro can tell me, support this because he's a member of the working group, we had a lot of difficulties identifying measures that actually need enforcement, that is forced enforcement. And you'll see in the guide, we have examples, but they are extremely rare. And so, do we need to abolish exequatur? Exequatur is very, very seldom actually present in this area. And this is in conformity with the study of Ian Curry that he produced for Parliament back in 2017. Exequatur is extremely rare. And, where it happens, geez, it should be just a rubber stamp exercise. Before we move into abolishing exequatur and providing rules and so on and so forth, let's weigh the pros and cons and, the balance of, advantages and inconveniences. I think it's important to do. Choose the court in advance. It's already possible. It's in Article 8.2b. You can actually you can identify a court in a power of representation or any written document, and it can be any court. That's not a problem. But the jurisdiction rules of the convention is such, that when this choice of court has to be, exercised, the state habitual residence actually has to let go jurisdiction, and there'll be coordination between judges. But that's the way forward. And this is what is actually one of the best elements of this convention is that only one court at any given time can have jurisdiction in order to avoid conflict of jurisdiction, i.e. to avoid conflicting decision. This convention is really, in relation to this, legal certainty and predictability, it's top. The last thing you want is to introduce rules where you will have prorogation of jurisdiction or conflict of jurisdiction. That will be really messy, especially in relation to people, which will be incapacitated at the time and will not be able to react or, to explain their choice and so on and so forth. Simplify cooperation, of course, we all agree this is the way forward. It can be done without a treaty. It can be done without a convention or a regulation. The bases are there. It's just to provide the tools. And tools can be developed through EU action grants in other ways, the same way we've done it with the 2007 convention, for example. And foreign law, yes, we agree, absolutely. And we're moving forward with this. We will actually develop a country profile for the convention. And we're starting this work in the spring with a view to have a country profile for discussion in October October next year. So basically, yes, ratification is key. All states in Europe needs to be members. I really enjoyed Adrian Valdquez actually suggesting that, in bilateral trade agreements, that we make a condition of states becoming a party to that convention in order to finalize an agreement. I think this is a brilliant idea. what about the following idea? States who will actually preside the European Union should actually show leadership and sign and ratify that convention during their presidency. The Minister of Justice of Latvia last year during the March webinar we had spoke in great favor of the convention. And I was hoping her state was actually going to sign the ratification during their presidency. Portugal was a member. Germany prior to that was a member. France, the next presidency, is a party to the convention. The Czech Republic is a party to the convention. But the next ones in line, I've just calculated, for the presidency all the way to the end of 2029. This is just 7 years. If you were to go like with this, you can get an extra 11 ratifications. In the next 14 states holding presidency, only 3 are parties. And I can actually highlight that Mr. Vasquez's state, Spain, will be presiding in 2023. It'd be great if your state could actually move forward with this, especially that they have actually reformed the PIL rules to actually, take on board the rules of the Hague Convention. So I will leave it at this. These are my thoughts. I thought this is useful and I hope it will generate some questions during the Q&A period. Thank you so much for giving us this possibility. And thank you for everybody in support of moving forward this convention. We really have to push this, and we thank you for that.
Thank you very much. On my side, your speech definitely generated tons of questions. As I said, I'm new to this subject, and I simply would like to ask several questions, to be quite frank. But before I have a chance to do that, we have our last speaker for today, Gerardo Ribeiro, who is chair of the HCCH working group charged with drafting a practical handbook on the Hague Convention. He is an assistant professor at the Faculty of Law of the Coimbra University, Portugal, pursues his PhD in Civil and Private International Law. He's member of the Center for Family Law, Center for Biometrical Law, and Center for Notarial and Registration Studies of the Law Faculty of the University of Coimbra. He will, as a chair of the working group, he will present the work of the HCCH working group on the practical handbook. Thank you very much. And Gerardo, the floor is yours.
Thank you very much, Aneta. Good evening to the participants and the speakers via share the virtual table. So I want to give my experience as a chair of the working group in the development of the draft practical handbook under the Convention of 2000. And it's a function that gives me the privilege of witnessing how it is possible to go ahead with such a challenging endeavor. So first of all, the benefits and disadvantages of the remote communication are evident in the work undertaken. However, in the absence of personal and indirect contact between the group members, there's still the advantage of holding more meetings at a more frequent pace and more intensive at each chapter, on each chapter or topic of the handbook. This allows the group to focus on the issues and problems at hand, in particular because it's not possible to give an analytical treatment of each chapter. The group in this geography is an asset. The group is formed by university professors, judges, members of central authorities, public prosecutors, lawyers, and representatives of public and private organizations in the field of adult care. In terms of meeting schedule, the work started on 14th April 2021, having been adopted as a norm bi-weekly meetings with prior sharing of the documents to be submitted for discussion and feedback from groups. Starting from the outline of the handbook, work was carried out on the drafting of each of the 14 chapters that make up the handbook and its appendix. The work methodology starts from the PB's initiatives in the elaboration of the initial draft for later obtaining comments from the members with subsequent reworking, if appropriate and necessary, and later in remote meetings, the discussion of the draft revised with the group members paragraph by paragraph. In terms of numbers, we are talking about the redaction and discussion of more than 70 documents. On average, each of the 14 chapters of the handbook had 5 versions following, to which we should add a version of the different appendix. In addition, the work on each appendix, there also the discussion of the final draft on the handbook as a whole, that, as Philippe already said, is being circulating with the floor. One of the pivotal elements for success of this convention arises from the foundational principle on which the convention is built, the need for effective cooperation between all authorities. The boldness represented by the convention, even though it is already came of age, was to put the problem of international protection of adults in perspective alongside the need for a new paradigm that demands an inclusive and non-discriminatory society. It was already evident at the time of the discussion and approval of the convention, namely because of the recommendation of the Council of Europe in 1999, that the solution goes far beyond the mere regulation and recognition of interdiction or guardianship decisions, as its long-forgotten counterpart, the 1905 Convention, had done, and later reinforced by the United Convention on the Rights of Persons with Disabilities. It is the flexibility of the legal concept used that makes the convention an enhancing instrument in safeguarding the interests of the most vulnerable people in its primary addresses, by providing a legal framework for the added and continuous protection of interests, regardless of where a person or their assets are located. However, the convention becomes more relevant when it is enshrined a special rule of conflict on the prospective autonomy of the adults as the ultimate realization of the self-determination and autonomy of persons, in particular the plan of further illness or the decline of their life. It follows that protective measures does not need to be an act of authority. In a sense, it has become international recognized sovereignty for each person, which is affected by a situation of incapacity or vulnerability, and allowing it to choose the applicable law and the way that their interests should be ruled and governed. The virtuality that such a conflict rule contains, Article 15 and 16, confers a consent innovating force on the characterization of the legal concept vis-a-vis its development of the domestic law. That calls for an operation that is neither dated nor rigid. The same autonomy is extended to the jurisdiction itself by giving force to the choice of the competent jurisdiction by the adult under the terms of Article 2, number 8, paragraph 2b. The plasticity of the convention solutions is a virtuous characteristic that gives its enduring relevance. It also gives special responsibility to judicial operators. The possibility of migration of the jurisdiction or jurisdiction limit to the subject matter of the measure of space and time all imply the existence of or the establishment of a relationship of mutual trust and cooperation. The competent authorities must have direct communication channels so that intervention coordination is possible, even more so when the transfer is only regarding certain aspects of the adult's life. The advantages offered by the convention extend beyond the European space, since the convention has a universal reach given the mission of the Hague Convention. The convention is also a clear and certain instrument in its content and application, accessible to all those who need to resort to it. And they are not only judicial operators or lawyers. Access to information is crucial to the success of the convention and decisively to the protection of the interests of the adults. So I'm sure that given the work carried out, the handbook will be a valuable instrument first and foremost because it is a product of the exchange of experience and knowledge of a diverse group that dedicates its time and work to its elaboration. So thank you for your attention.
Thank you very much for the insights of your work. And now we will proceed to the questions and answer session. And I would like to begin with posing a question to Sala, because it seems that there is a little bit of I wouldn't call it hesitation, but maybe disparity as to when I was listening to your presentation, what really is the interest of the Commission. So is it should the work go in the direction of protecting vulnerable adults in international situations, or just assist EU citizens who, due to the increasing mobility, are changing the place where they live or are functioning. And you mentioned that the factor that has an impact on increasing the work is the aging of society, aging of European nationals, hence them needing more help or assistance. So actually my question to you would be, is it more about helping or is it more about assisting? And what really was the trigger that initiated the discussion and interest, increasing interest in the subject? Thank you. And of course, please, to our very many attendants, do pose questions, which are many at the moment. But please feel free to add even more.
Okay. Thank you for that question. So whether it is about the helping or assisting, I would say both, meaning that assisting in the sense that they keep the autonomous possibilities as by the UN Convention. So this is something actually where the Commission is starting. The EU, it's one of the rare, the UN Convention is one of the rare international human rights conventions where the EU itself is a party. At the same time, or let's say I don't see the contradiction on this. It is also then helping in practical ways. So we are looking at both as the EU citizens moving to another country. So because this number has been increasing, and actually the number of the elder citizens which are more easily covered with the need of the assistance or help has been increasing. So this is one of the background. International level, we support our position is that we support the Hague Conference, the convention, so 2000 convention, that would bring then the third country, so whoever is then party to that convention, so it would be broader than the Europe. And the EU position is that we are supporting multilateral solutions when we have found that type of the basis. So that's why it is also the promoting of the Hague Convention. How we still see currently is that we have now tried by the mere ratification recommendations to the member states 10, 15 years, or let's say now 20 years almost, then it's from 2000, and we don't have even half of the member states there yet. So politically, we think that it requires stronger incentive to the member states, and that kind of incentive would come from the common EU level measures. So this is then the reason why we want to also look at this addition and added value to the European citizens, so that we are actually through that we are then reaching the impact to the multilateral level, to the outside of the EU too.
Thank you very much. I would like to follow on the question, on your answer, but first I would like to pose a question to Philippe from Paul Patrider. And he writes, as we know, the adult habitual residence is the main connecting factor of Hague number 35. What could be the possible solutions to the problematic aspects of identifying a vulnerable adult's habitual residence?
Yeah, well, that's a very good question. As for every Hague Convention, the concept of habitual residence is not defined. It is a question of fact. So there's no, one way or, one shoe fits all. You have to look at each situation on their own facts, own basis. And you have to look, I would think that, where is the center of life of this person? And then you look at all the different facts that actually may help you in that respect. Of course, the length of time that they've been there, if they are there, on a permanent basis, and, where are all these other connection issues in relation to their life. there could be different, things to look at. So it's a really, in a case-by-case basis.
Thank you very much. And a follow-up also to Salah's answer is from Adrian Ward, who writes, helping or assisting or empowering. That's also the point of view that you can, what one can pursue. And then we have a question to Gerardo, I guess, from Mustafa Ebain. Does the report take into account the intellectual and cultural diversity among the countries of the European Union and the difference in family customs and traditions in dealing with adults, especially among immigrants, in a way that provides dynamism and flexibility in the appropriate legalization for all that contributes to making the European legal system inclusive and contributes to promoting integration into European society in general and reducing separatism and what can result from it? Yes, and
well, well, what I can add or to answer to the question, well, we are doing a handbook, a practical handbook in the implementation of the convention, and so it's mainly the working and the putting to force or interpretation of the rules. So we're not taking into consideration specifically the provisions that are in the European member states, even though that domestic law is also taken into consideration when we think about the institutes that are the objects of the convention. But the problems I think that are asked is related to immigration, and if it is so, the convention doesn't apply to that, only to giving room to the application and competence or jurisdiction in matters relating to powers for someone to represent, if needed, a vulnerable adult.
Thank you very much. And Pietro would like to take the floor. Please, Pietro.
Thank you. Yes, on this particular topic, which is very interesting, let me just briefly remind you that the Hague Convention of 2000 is somehow already equipped to deal with problem of cultural differences and inclusion. First of all, the very fact that habitual residence represents the key connecting factor is a powerful tool of inclusion, because through the use of habitual residence as a connecting factor, all those who are socially tied with a particular country are treated equally, regardless of whether they were born in that country or they are newcomers. At the same time, the Hague Convention, when it comes, for example, to the applicable law, has in itself the tools to ensure that cultural differences are taken into account. I refer in particular to the provision according to which in taking measures of protection, the court or the authority with jurisdiction normally applies the law, the forum, but a possibility exists, in particular when the interests of the adults so require. A possibility exists for the competent authority to apply or to take into consideration the law of another country, and this may be the law of a country with which the adult in question has cultural ties. So since cultural differences are a case-by-case concern, you cannot decide once and for all whether and to what extent for everybody culture matters. Identities are multiple for each of us, so things are very complicated. It is interesting to note that the Hague Convention as it stands provides for a balanced consideration of both a concern for inclusion and a concern for the safeguard and respect for the cultural identity of each of the adults concerned.
Thank you very much, Pietro. And I'd like to follow on what Salah said and also about what Philippe said. And actually, I think it's kind of a leitmotif coming back in all of the presentations. The problems with adopting the convention, with joining the convention, and again, as an outsider, I can't quite grasp. This seems to be a political problem because the merits are there, the need is there, and it is increasing. And what struck me somehow, and again, when you come as an outsider, you see things maybe differently than people that are engaging in the discussion for a very long time. But when Philippe said that pandemic is a reason why member states do not join the convention, logically speaking, it should be the other way around, because pandemic increase the problems that European citizens face. So the logical step would be to join. And then what Salah was saying about the increased mobility and the need to assist, or what Adrian said, empower European citizens, it seems to be like a contradiction that, again, as an outsider, I cannot really understand. Can someone please explain it to me?
Yeah, well, if I may, if I can jump in. I mean, I look at it this way, and this is something that we see all the time at the Hague Conference, is, of course, the protection of vulnerable person in the, at the time of a pandemic is a priority. Their priority is, the incapacitated adult in their state. They would actually really, I mean, they want to include everybody in these reforms, and they do, and they've been working tirelessly. The issue is that the cross-border element is very small. It will only include 1%, if less, way less of the citizens. And their priority is to, cover every incapacitated adult in the state that need to be protected at this moment. But somehow, the international aspects becomes less important in comparison to the national aspect. And this is what we usually see. They want to get, their substantive law rules, in order. A lot of them have been working on the implementation of the 2006 convention. But, it'd be interesting to hear from a state like Ireland, for example. Their legislation has been in order in relation to the 2006 convention for the last 5 years. Why they have not signed and ratified the convention, I don't know. They are the best place to answer that question. But that's the reality we see in all our, conventions. The national aspects always comes first, and they work at it, and they do a good job. But then when it comes to the international aspect, this is a really smaller number of people, and you see it in court operations. They will work on domestic reforms that deals with domestic cases first. And then they will look at the international situation because cross-border cases that go to court, actually it's probably less than 1 or 2% of the caseload. And that's the reality. Salah may want to add on this. She has her own view from the commissions.
Yes, please do, Salah. And then Pietro, are you raising your hand again? No. Yes, okay, so Salah and then Pietro, and then we have another question, and then I have a follow-up question. I don't know if we manage.
No, thank you, Philippe. I think that you said that it's only the member states who know why they are, or the states who negotiated the Hague Convention who know why they don't actually progress with the ratifying faster than it is. But it's correct that politically it's not yet a big problem. Member states do have their own international private law rules already. I mean, here what we want to do is actually then to harmonize them, bring them better together so that it is easier. This is what we bring with these international conventions, but they exist. I mean, member states have their own rules. Sometimes they would conflict, and that would be then easier and that way simpler if we can solve that through the international rules. And so we think that there is despite if one takes despite of one person, there are so many million Europeans that it is actually an issue. We talk about millions of people still, and that way, on that level, we think that there is a possibility to actually then to in all these words to empower, assist, and help. So in all that aspect. So that is, but I'm very much inviting, if you have any in the participants, any national authorities or somebody who is working for the governments, that they would come back indeed with a more precise reply.
Yeah, I'm from Poland. What can I say? And having been working for a government for a very long time. Pietro, please.
Very quickly to mention two reasons that sometimes are indicated as reasons that justify non-ratification, but they are reasons that are just not justified. First, financial concerns surrounding ratification. Experience shows that there are no significant financial implications arising from ratification, so states should not be worried about this. Second concern, some states fear that by ratifying the convention, they might become unable, through in particular their consular officers, to look after their own nationals abroad because of habitual residence being the key connecting factor. Well, again, this concern is exaggerated, because the Hague Convention itself provides the states of nationality of the adult concern with an opportunity to have a role to play in protecting the national. So again, it's a concern that is not justified. These states that raise this concern should find other reasons if they do not want to ratify, if I may say so. Thank you.
I absolutely agree with Pietro.
Yeah, thank you. Thank you very much. We have intervention from a participant, Camelia Toder, who congratulates us on a very nice webinar. Thank you very much. She writes, waiting for the member states to ratify the Hague Convention and the EU to legiferate, I think that some case law of the Court of Justice could help answering some questions raised today. And she mentions C417/15 and C404/14. And she wishes us a nice evening. Unfortunately, I do not know much about those cases, but if any of you would like to respond to that. No. Then
it is indeed very useful, because this shows that issues, I refer in particular to the first one, which is the Schmidt case, if I'm not mistaken. First, it is useful because it reminds that in real life, situations involving incapacitated adults and their assets in that case are present, arise in practice. So this is important. And it also reminds us of something that would require some discussion, not tonight probably, of the issues that arise from the coexistence of different legal instruments. We have some instruments within EU legislation that somehow cut across protection cases. The Schmidt case is not a protection case in itself. There is a protection element in a civil case covered by the Brussels 1bis regulation. So this reminds us and reminds the Commission, although the Commission is very well aware of this, that when it comes for the European Union to get involved in this area, an exercise, a delicate exercise in coordination is required in making sure that the implementation of the Hague Adults Convention fits well in the existing legal framework, which is already very dense in the field of private international law, although the protection of adults itself is not covered.
Thank you very much. Now it's the time for last words for the seminar, if anyone would like to address us with. And if not, Let me thank you.
Maybe
Oh,
just
no?
just a small word. I mean, look, I mean, we welcome, of course, the work of everybody, ELI, the European Commission. I mean, this is fantastic. Yes, if there's a proposal that, you know, would complement the convention with added value and no conflicts, of course, it is in the spirit of Article 49, paragraph 3 that Pietro, you know, mentioned earlier. But I just hope that if that is the case and we move forward, I know the resources are very scarce in the, you know, states in this area. I just hope it will not take away resources that are trying desperately to work on the implementation and ratification of the Hague Convention, because this is something that we very often see. It's the same people working for the Hague, working for the, you know, legislative proposal that the Commission, and we just hope it will not have a, you know, a backlash effect. But on the reverse, we hope that, you know, it will get them to focus and do the right thing and ratify this convention as soon as possible. So where we, you know, we applaud all this work and hope that it goes in the right way. Thank you.
Thank you very much, Philippe. And I just seen Richard appearing on the screen, so may I use the occasion of asking you to give us your view. We still have a few minutes on the problems with ratification, which you yourself mentioned in your speech, and hesitation when it comes to doing it.
Thank you, Annette. I mean, I think that from the UK's perspective, as Pietro mentioned, the great fear in the UK, in England and Wales, was that ratification would involve extra cost. That's difficult to justify, since the Ministry of Justice thought that only one extra person would be needed in relation to ratification. But clearly money is so tight in the Ministry of Justice that it's been postponed. I think the real problem is the political one, that generally members of Parliament are not confronted by day-to-day problems of cross-border issues of capacity. And I think what they don't see is the struggles that ordinary people have to go through, particularly with elderly relatives in another country, and they want to bring them home, and then trying to deal with bank accounts and other issues there. However, I'm glad to say that I think one of the few good things out of Brexit is that the UK has had to concentrate much more on the Hague Conventions in relation to private international law, and we got the UK government to commit to ratification of the Hague Convention for England and Wales. I think Northern Ireland will take a little longer. And again, as has been said, I'm sympathetic to Ireland, who've been struggling with how best to produce new law that complies with the UN Convention, and that perhaps has delayed for them ratification. I think as a practitioner, I would say the perfect often gets in the way of the good, and that trying to make the perfect law that is perfect for the UN Convention means that Ireland has still been stuck with historic 19th century legislation for capacity issues. So I would say better something than nothing. Of course, one wants to make everything as good as possible, but don't let the perfect get in the way of the good.
Thank you very much. And as a former legislator, I would right away answer to that if you don't try to make it perfect, then you will be attacked for making it not good enough. That's the, I'm sorry, that's the balance you have to strike. And I understand the fear of putting forward something that will be heavily criticized by practitioners and academia. You know, there is no nicer thing than to criticize someone's work that is imperfect. So I do understand this position in a way, but we are running out of time. So let me just say that this was, from my perspective, extremely interesting discussion, and I hope our audience shares this view. And I think it was really interesting to see the various levels on which discussion is pending and is developing. And while there are evidently political issues with the convention, there is already an issue, power on the level of European Union to move forward with new concepts and new ideas, and those are clearly needed. So I think that, speaking for ELI, the project was a wonderful idea, and thank you again, the reporters, for bringing it forward. But I think there is also a future for a space for discussion in this area. So thank you very, very much. And I hope that was not the last time that we had a chance to speak.